Donald Trump loves emergency applications to the United States Supreme Court. Why? Because it takes away all of the guardrails that the Supreme Court has set up as a deliberative body to make their ponderous decisions. They like briefs. They like oral argument. They like lots of time. They like to talk to each other in the hallways of the Supreme Court and try to change each other's minds. And Donald Trump hates all that. He only wants fast, knee-jerk reactions. So he's pressurizing and stampeding the United States Supreme Court with phony emergency applications. He's filed already a dozen of them. And it takes away all the things that make the Supreme Court great. A deliberation, full record, full briefing, oral argument, time to contemplate, time to ruminate and marinate. It's all gone. It's all gone. All of these decisions we've talked about since the Trump administration got back into power, all that we've been talking about are these emergency application decisions by the United States Supreme Court. 6-3, 7-2, 9-0, 3 paragraphs long, 1 paragraph long, no paragraphs long. Is that any way to run a democracy in a constitutional republic? We don't think so on Legal AF. And here's a clip.
You know, there's this other area here, and this is kind of the procedural thing, right? Where Trump's trying to now use procedure to do bad stuff, to take your Social Security information. Because what Trump wants to argue is that the presidents are good people. We don't harm you with things. We just want to be more efficient and root out fraud, right? That's all we want to do here. Now, the law creates so much presumptions that presidents are good people. that there's a lot of deference that's given. So in lawsuits, one of the issues is there's got to be an injury. And normally we wouldn't say, well, the executive branch going about a process of accessing data isn't nefarious. No, right? Normally we would say, okay, I mean, you know, we elected the guy president and presidents do president things and okay. But what happens when the president picks an oligarch like Elon Musk, who we know is a bad person, and the president is a bad person who hates our judicial system and is out there saying and doing bad things? What do we do in those situations? Now, when they want your Social Security data, when they want your information, and we're like, I don't want to give it to, why is Elon Musk a special advisor? I don't want to give this guy my Social Security information. But the regime argues, yeah, but you haven't been injured yet. Elon Musk hasn't sold it. You haven't proved that he's sold. We just want to look at it. And looking at it isn't an injury. And right, sometimes courts look at injury like a simplistic example is car accident, right? Car gets into an accident, someone gets hurt, injury. But would you say an injury is, I'm worried that there's going to be a car accident later because I see how people drive at a certain period of time? The court would say you haven't been injured yet. There's no injury in fact. So when we speak about the Social Security case, the judges who have ruled so far against the Trump administration are basically having an injunction and saying, look, we need to just preserve the status quo because we don't know what the hell DOGE is doing. Trump saying, I'm appealing that. There hasn't been an injury yet to the people. Your injunction is premature. So then it goes to the Court of Appeals. It started in a Maryland federal court, right? Then it goes to the Court of Appeals. The Fourth Circuit Court of Appeals sits over the District Court in Maryland. And it went in front of what's called an en banc panel. I won't confuse you with procedure, but it was heard in front of all of the judges. Usually it's a 3-judge panel, but in special circumstances, it could be heard in front of all 15. And it was a 9-6 ruling along party lines, where the Democratic appointed judges, by and large, were the ones who said the injunction blocking the Social Security data from getting to Musk, that should stand, that it should still be blocked. The Republicans did not say that Elon Musk was doing right. That's the point that Popok was making earlier in the show. But they said, but the people who brought this case, the AFL-CIO, the unions, represented by a group called Democracy Forward, who does a great job, they haven't proved yet that they've actually suffered the injury. So we have to then default to these good faith beliefs in the executive branch. So that's it's nuanced, but that's what's going on. And you see how someone like Donald Trump, who's breached contracts his entire life, implied in every contract is a covenant of good faith and fair dealing. That even if something's not spelled out specifically, it's implied that the parties will behave in good faith. So our Constitution is like a contract. If you go read the amendments, some of them are just one sentence long, but there's a good faith belief in what their intention was and how to follow them. So Trump, the way he breached contracts his whole life and ripped them apart, he's doing the same with the ultimate contract, which is the Constitution, and he's abusing the good faith presumptions that federal courts throughout history have given to the executive branch to say, I want the Social Security now for Musk. And it's an emergency. Why? Because we're the executive branch. We're good guys. We're good. We're the good guys. You're going to say the president's a bad guy? We're not. So that's what's happening. So Trump, on an emergency basis, through his Solicitor General, John Sauer, goes to the Supreme Court on that issue. We have not got a ruling yet. The Supreme Court's ordered an emergency kind of briefing on this issue. So we'll find out what happens on this issue. But that's the dynamic of what is taking place. Popok, I think I covered a lot of it. I want you to comment on it.
Yeah. But
But then when you do it, then you could transition seamlessly, because I think talking about the Solicitor General, the standing ovation, and then I think a little bit of Katonji.
Okay, great. What we're watching, what Ben you just described in detail. What we're watching is the Trump administration using and misusing and abusing the emergency petition process, the shadow docket process, to their advantage, to try to stampede a body, the Supreme Court, that does not do well under pressure and is not built to do well under pressure. They don't like emergency applications. Their procedures for it they're not built for it. They're a more deliberative, tortoise-like body. Donald Trump knows that. And what Donald Trump doesn't want is what we want in the 60 or 70 cases that go before the United States Supreme Court. We want the deliberative process to prevail. We want a full record of facts. Donald Trump doesn't want that. We want full briefing, 3 big pieces of paper filed by the parties and others to help guide the judges. Donald Trump doesn't want that. We want the judges in caucus to talk about the case, lobby each other, and try to get votes over one or the other before the majority opinion or dissents are written. Donald Trump doesn't want that. We want the oral argument, including one that we're doing regular oral arguments now on the Legal AF YouTube channel. We just did the one of the Oklahoma religious charter school that went on for an hour and a half. We had 50,000 people join us for that one. We want the oral argument. And then we want that long, Trump doesn't want oral argument. And then we want that long deliberative process of 1, 3, 5, 8 months while they're working behind the scenes. And the law clerks are running back and forth with opinions and all the things you and I read in the books like The Brethren and other insider accounts of the Supreme Court to get to that 40, 50, 60-page decision that will then guide us. If we lost, we'll know why. If we won, we'll know why. Trial judges will know how to govern off of that. Donald Trump doesn't want any of that. What he wants is these quick, knee-jerk, snap decisions, which are only based on 2 briefs, an incomplete record, no oral argument, and then we get, and what comes out of junk in, junk out, right? What do we get? We get 4 or 5 paragraphs that you and I have to daven over. What does this mean? Why is this sentence here? Foreign policy powers combine. What? And that's what he wants. He knows, Donald Trump knows, that if he forces the issue in a phony emergency, and that's the entire administration is summed up by the phony emergency. Phony emergency on the economy, tariff war. Phony emergency against Venezuela, Alien Enemies Act. Phony emergency, 12 applications for emergency relief, of which none of these are true emergencies, up to the United States Supreme Court in order to try to get the votes and grab them fast. He knows that 80% of the time or more, Alito and Thomas 100% of the time, Kavanaugh and Gorsuch, the other 80% of the time, are going to, if forced, will back the Trump administration almost all the time. That's 4 votes right there. He only needs 1 more. And he knows that for him, for Trump, because they support the rule of law and democracy, Jackson, Kagan, Sotomayor are lost causes, which means he only now, under this scenario that I just provided of emergency, the rushed stampede of the Supreme Court, he only has to try to get Roberts and or Amy Coney Barrett. He only needs 1 of the 2. And we have to fight for both. Yeah. And then in cases like we just saw this week, where Amy Coney Barrett says, yeah, I can't hear this case because my best friend, the goddaughter of one of my kids, is represented one of the parties, leaving it 4-4. Oh, what to do now? But this is what we're watching. And the sooner, and I've called this out on a hot take, that the justices like Kagan and Sotomayor and Jackson, who sit over certain of the circuits, start rejecting these applications when they're first brought to them, rather than refer them over. I know they want to be like, well, we don't like shadow docket. We get accused of shadow docket. We're going to send it over to the full 9. Screw that. Kagan right now can kill something that's right in front of her coming out of California, and she should. And that's it. They have to start punishing and pushing back against the Trump administration's exploitation of the emergency docket method to try to get rulings in their favor, even if they're short-term rulings. You see the political capital they try to gain from it. Oh, we won. Oh, and then it's 3 days of news cycle about how the Supreme Court, quote unquote, ruled in their favor, when you and I both know not so fast. We're not even going to be at this term is going to be over now. The last oral arguments are now happening. This is it, except for emergency applications. Things we're talking about that are going to be ruled on in the Trump administration, you and I are going to be spending an inordinate amount of time come October when the new term opens, but not now. Now we're talking about all the procedural things. So now we had in the rule, perfect way to segue into the rule of law week, which I'll be frank, in 35 years, yeah, it was a date on my calendar. I mean, but when you're in the Trump era, rule of law day becomes a day of action. That's why all my friends were sending me videos from Foley Square out in front of the courthouse Donald Trump was convicted in. Federal judges, we put up judges who support Midas Touch and Legal AF in shorts and clips on our Legal AF YouTube channel. But, for me, it was just like another day. Now it was like a serious, like I renewed my vows and my oath to the Legal AF community, which I hadn't done in 35 years. It was really, really important. Welcome back. About 5 years ago, I founded a podcast with my friend and colleague, Ben Meiselas, and we called it Legal AF. I mean, it started as Legal Roundup, but it became Legal AF. And now that brand, I think, stands for something, and our audience does too. It stands for telling you the truth. It stands for not blowing smoke or sunshine. It stands for not patronizing you. It stands for joining together in fellowship in a resistance against a lawless president that does not respect the rule of law. So if you like what we're doing, come on over, watch us on Wednesdays and Saturdays at 8 p.m. Eastern Time for the live recordings on the Midas Touch Network. Follow us on all podcast platforms. We've got a new Legal AF Substack. You want to really geek out, including, with the actual court filings that I read from or analyze from, they'll be there along with other commentary. And I do a morning AF summary of the day's events and things I see in the future only on the Legal AF Substack. And of course, we've got Legal AF, the YouTube channel at Legal AF MTN. I curate that channel in collaboration with the brothers on the Midas Touch. I got a dozen contributors, including 2 new ones. Amazing. There are resident historians, Sidney Blumenthal and Sean Wilentz, every week, every day, putting things in historical context only on Legal AF, the YouTube channel. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.